I have at least right of consideration. And
No, this is your case, basically.
my lord,
This is your case.
this is my case because due to non-consideration, he is taking the undue benefit being
Yes,
senior to-
Mr. Monroe.
Then, my lord, only thing I will show, my lord, my representation, that is at page, I submitted my representation at page, first representation I have submitted, then second representation submitted, no response given.
Where?
That is what I am saying.
Page 39.
This is very vital.
39.
No, page 39 is the second representation.
Hmm.
My representation, page 70 of my affidavit in reply. That I could, my lord, that is, I have specifically stated my state, I am just reading for your lordship. Regarding first promotion to the post of senior inspector boilers, it is a representation on 26 December 2022, when there was a regular chief inspector of fire. Prior to his retirement, I submitted this representation on 26 December 2022. I have the honor to state that I have been serving at the capacity of inspector boilers and at present posted in the office of chief inspector of boilers, Assam, Guwahati. That's sir, I have been rendering my service in the department since my joining on 5/1/1991 without any break and have still not received any promotion till date. That's sir, 4 numbers of post of senior inspector boilers are lying vacant in this inspector.
Okay, we got it, Mr.
Then he also requested that at least promote me on in charge basis. He has been transferred to inspector at Silchar and junior has been made the in charge. And now, my lord,
You have not challenged the order of transfer.
my lord, not. I am there. I mean, because
Okay. Take your seat. Yes, Mr. Monroe.
My lord, actually, my learned fellow friend, whatever is submitting, actually he is worked by Estoppel, my lord. Kindly have a look, my lord, in my affidavit, Annexure 1 at page 53.
Your
I'm
affidavit
coming
of
by-
respond number 3.
His own letter, first of all. That was addressed to the Chief Inspector of Boiler, Assam, in charge, my lord, whereby it was specifically he has admired, my lord, the entire work that has been done by me. And he has no objection in continuing as a, my lord, Chief Inspector of Boiler, first of all. Then, my lord, lordship, in para, my lord, it is, my lord, so far, my lord,
Just tell me why the promotional exercise is stalled.
my lord, I am happy if, my lord, the promotional exercise will be
Okay,
taken by the
madam.
department concerned, my lord. My lord,
Why?
but before that, my lord,
Hmm.
I want to show one thing, my lord, regarding the promotion. Seniority is not a criteria.
No, consideration. You promote
no,
anybody
no,
you like.
When a merit come, my lord, suitability, first of
Oh,
all.
that is
Seniority
it.
come in later. But,
But for placement in before the DPC, seniority will be followed.
but how, my lord, I have been appointed, kindly have a look, my lord. In my para, affidavit, my lord, page 47, 6, para 6. They will broadly record everything, my lord.
You have the records with you. 47, yes.
47, para 6, my lord. That in response to the environment made in para 3 of the answer.
So when you were selected for this temporary appointment,
After
your
this-
merit was
Yes,
Where?
that committee was constituted. That
where?
committee-
Where is that?
I mentioned, my lord.
Where?
They will be this thing. I'm saying to say para 6. In response to the environment made in para 3, the answer deponent has nothing to comment as per the those are matter of the record. However, the answer deponent reiterated the provision of the rule 8. My lord, rule 8, my lord, which provided that in every cases where a junior member of a service is a cadre is selected in a preference to the senior, that cadre and the committee shall record in writing the reason for such superannuation and as respect of the selection shall be based on merit and the suitability with due regards to the seniority and other aspects like a personality and the character that tact energy and the general intelligence, then integrity and the previous records of service. In the instant case, on the retirement of this Sumendra Nath Chaudhary, the then CIB Assam, on attaining his superannuation on 31/12/2022, it became essential for the temporary arrangement of the keep the charge of the CIB until further order of the alternative arrangement is made. Out of 7 members of inspector of boilers, including him, working in a various places, and accordingly as Secretary, Labor and Welfare Department, after considering all the records of 4 inspector of boilers forwarded the proposal for temporary arrangement to give the charges in charge CIB to the deponent, that is myself, till alternative arrangement are made in the interest of public service, and being forwarded the same to the Principal Secretary. The present deponent was allowed to hold the additional charge of CIB Assam temporarily by order dated such and such, and getting the final approval from the minister concerned, and strictly following.
We have got your point.
Yes, my lord.
But tell me whether this is the selection contemplated under the rules.
No, my lord, there is a rule. If this something is to be given in temporary, my lord, that is a procedure.
Show me.
That is a rule, my lord.
Your departmental rule.
Yes, my lord.
Show me.
He relied, my lord, this thing. Same
Where?
thing. In para, my lord, I am coming. My lord, this is 7 recruitment and promotion rule. It is page 23. It is started.
Hmm.
Then the my lord lordship can come to straight, my lord, the preparation of the select list of candidates, my lord.
Hmm.
Oh, no. Before that, my lord. Yes, my lord. 7 rule recruitment and promotion rule.
Hmm.
7 will come.
Hmm.
For the purpose of the preparing the select list mentioned in Rule 6B and C, there shall be a selection committee consisting of the following members: chairman, Assam Public Service Commissions, and where the chairman is unable to attend, the member of the AP.
So if I compare rule 7 with your paragraph 6, where is your statement that your selection was made by this committee?
My lord, whenever a temporary arrangement is
Where? Rather, well, it says you cannot have a temporary appointment beyond 2 months.
I am not happy, my lord. I am ready to accept because when
Yes, madam.
my
Why?
government
Why is the
and moreover, my lord,
why is the selection not?
one thing, my lord, so for my lord, information is this, my lord. The present recruitment rule is, my lord, promotion rule is, my lord, under scrutiny and is for to be giving a final approval by the government. So, my lord, government is not giving the consideration of the promotion.
Well,
rule.
what is there that will hold the field?
They will say these things, my lord.
Where is the rule? What is there
But
that will hold the field?
present rule is, my lord, this is final stage, my lord. This is, they will come with the all
Madam,
the
why?
hands full, my lord.
That instruction I have to.
Get it by 2.
My lord,
This
you-
cannot be permitted. He is continuing from when?
It is, my lord,
31st December 2022, he is
December.
holding the charge.
22. 3 years.
I am
2.5
ready,
years.
sir. They come for the regular.
By this
recruitment.
time, my
We will and get that file wherein the consideration was made as per his para 6. Get that file
For Monday, Lordship.
today, 2 o'clock. You have it, get it.
Because the
Historical document.
entire record with them, my lord, regarding that.
That is her headache. What is for you?
Lordship, but can you-
Today is a holiday. State is holiday.
Well,
State
yes,
holiday.
yes,
नहीं है.
Monday, Lordship.
Heard the parties at length. Hearing remains inconclusive. Also, Ms. S.G. Borua, learned government advocate, shall receive instructions from the Secretary, Labor Department, as to why the selection process for promotion to the post of Senior Inspector has not been carried out since the year 2021, when a proposal in this connection was made by the then Chief Inspector of Boilers, Assam, via his communication dated 6/8/2021. Further, the relevant file wherein the processing with regard to holding of the charge of the post of Chief Inspector of Boilers was so made, and the respondent number 3 herein was so permitted to hold the charge, be also placed on record, but placed before this court. Full stop. Further, the Secretary, Labor Department shall clarify as to how the appointment of the respondent number 3 was being continued, temporary appointment of the respondent number 3. That is an additional charge.
It is not.
Registered to list this matter again on Monday. Tuesday.
Tuesday, madam. That will be
Tuesday. Tuesday.
70th.
So boils down, both are agreeable, hold this election.
My lord. I am not happy at taking the in charge. I want regular.
Because your rules does not provide for any external entry to the post of additional chief inspector of
But
police.
reason is, my lord, they are not finalizing the, my lord, the rules. This is the reason, my lord. This is
And
under
madam,
consideration.
at the outset, I'm telling you, don't come back with that reason. You'll be in trouble. You have a rule, follow that till you get the new rule.
Till all are, my lord, inspectors, not one of them will be promoted to the same.
That we'll see on the next lecture.
Two, my lord,
How you will be eligible because you don't have an access to the post of chief inspector when you are in the inspector cadre. You will have an access only once you become a senior inspector.
Yeah.
5 years, additional chief, 8 years is,
all criteria, my lord, I have also fulfilled, but thing is, my lord, I have not taken my own, my lord. This is given by the government, my lord.
No,
This is the thing, my lord.
you have not, you have,
I-
both
if-
have fulfilled the criteria.
My humble submission,
Both
my lord,
have
if I
fulfilled
go
the
for
criteria for senior
No,
inspector.
my lord, if I go for the, my lord, regular, my lord, promotion, my lord, I will be eligible. I am the person only. I am giving you this one record.
You cannot.
My
You
lord,
again have
Well,
to be.
his, my lord, service
Mr.
career is
Mr.
not good, my lord, at all.
Mr. I'm not concerned. I'm only concerned with the fundamental violation of the fundamental rights.
But the first, my lord, senior inspector, then, my lord, additional, between two, my lord, there is two posts, all are vacant, my lord. None are being.
My
That's
lord,
what I'm telling.
No, they have
now
come with the all details, my
vigilance,
lord.
vigilance inquiry is
Mr. Nath,
going in against.
Mr. Nath,
Vigilance inquiry is going against. him.
that is another
is-
thing.
if
That is of no
possible.
use. But until and unless there is a charge sheet, he cannot be
Yes,
Yes,
denied.
my lord.
So
This is
forget that.
different thing.
Don't bring this unnecessary things
Yes.
here. Mr. Monto, even if you are made a senior inspector, you cannot be a chief inspector
I agree, my lord.
because you will not have the residency. You will still have to continue holding on. We'll
But
see how it
the
can be
government
resolved.
decided, my lord. None is
Tuesday.
included, my lord.
Oblige. Thank you.
89.
Lordship, the matter here relates to regularization of master role workers.
You're withdrawing or we pass orders?
Lordship, and placed a matter regarding Lordship, the Upenda's one of the judgment already passed, Lordship, that is, in the past, the copy of the judgment,
Madam, come to page 24, your prayer.
Lordship,
Page 24, your prayer.
24.
Yes.
Lordship, the prayer part.
Hmm.
Lordship, here I'm seeking a direction from this honorable court to regularize, adjust the services of the petitioners in the sanctioned vacancies, lying vacant under the Directorate of Geology and Mining, Assam pursuant to cabinet decision dated 22/7/2005 and order dated 20/12/2013 passed by this honorable court subject to the result of the WA number 45 of 2014.
So WA 45 or 14 has come.
Yes, Lordship.
Therein it has been said no regularization.
Lordship.
You will be entitled to that minimum scale. How can you go beyond that? You filed a review dismissed, Supreme Court till now, nothing. So
In my case, only thing is that Lordship.
how can with this prayer,
prayer
with
is-
this prayer, you fight it out in the Supreme Court? Whatever happens will happen then. If the Supreme Court allows your plea, you will get back everything.
The only thing is that Lordship, the petitioners were appointed against sanctioned vacant post.
Be that as it may, you were there before the division bench.
Lordship.
You accepted it,
Lordship.
nothing more.
All the petitions were clubbed together, Lordship, in that petition.
Upendas, you are the main man.
Lordship, Lordship.
And because of you, the other casual Mazdurs are getting a better remuneration package.
The
They
petitioners.
may be blessing you. And you cannot now take this forward.
Only thing I'm placing here today, Lordship, that they are appointed against sanctioned vacant. post.
That
Yeah.
cannot be gone into, madam, here. You filed a review also on that point. That was dismissed by the division bench. How can a single bench now go and question that? You are in the wrong court. You withdraw or I dismiss.
Lordship, fix it tomorrow, Lordship. I'll apply an instruction. Tomorrow, Lordship.
No instructions are required. This is legal. If you want, I'll have it at 2 o'clock.
Two, Lordship.
Anything else to add? Nothing. As an officer of the court, not as a counsel,
Yes.
Officer of the court, anything. They are also not supporting. Yes,
Item number 27 and
27 we are disposed of. We'll pass the orders. 20?
27 and 28.
We have disposed it of. We'll pass the orders.
What's the
Anything-
point? Take care of the rule 13 of the conduct rules also. Without permission, what's the?
That I have, my judgments are there. I said it is permissible. So I'll have to follow that. You have a beneficiary of that also. As an advocate in some cases. So don't take a volte-face.
There is a notification by the director.
We can't. I'll go by my decision. I said that is permissible and I'll not go beyond that. But his seniority, whatever it is, that rest part we'll see.
Till then also I will be continuing. I am holding the.
You will get the order by tomorrow, latest by Monday.
Yes.
Please. you.
May I pray, your Lordship?
Hmm,
Lordship, by now I am fit and fine.
hmm.
I was unwell for quite some time. That
My lord, here, here, my lord.
Oh, that
matter, I am his
Uh-huh.
clerk. I am his clerk.
Huh?
So,
I am?
writ petitioner before your Lordship is, he was the LD of that Hussain Ali, that
Okay.
sub-registry office. Division
No,
bench
it-
judgment is also,
Before
Uh,
my lord proceeds to hear the matter, that may I pray for an accommodation of filing an affidavit by the final, because this matter is 2015 matter, I can understand. It was dismissed on one occasion, it was referred, and then the petitioner waited till the outcome of Hussain Ali. Now, my lord, this matter is being again listed before this honorable court. We have communicated to the finance department, because my lord, new pension scheme is within the domain of the finance department. Let me file an affidavit, my lord, thereafter lordship will definitely take a call.
I have filed a detailed additional affidavit after the rate appeal was dismissed by government. Everything is there. Law is also in our favor. Finance department affidavit is in fact not necessary. If they want, I have nothing to say. Let them file.
You want them to file?
Hey, if your lordship thinks that it is still necessary, but from
Because-
the judgment of my lord justice.
See,
Dictator-
Mr. Counsel, the objection of Mr. Borpujari is very limited, but it goes to
Yes.
the root of it.
Yes,
The difference between Hussain Ali and Siddiq Ali is Hussain Ali was appointed
Cargo.
that by the government
Yes,
and Siddiq Ali was appointed by Hussain Ali.
Hussain.
Now, whether the appointment by Hussain Ali would also tantamount to be an appointment by the government.
Yes.
Get my point?
Because in the 1984, the April, that order, there was a clause, Lordship. Hussain Ali was empowered. Lordship, may I just point out?
Yeah, point out.
Yes, kindly come to Annexure 2 of my writ petition, page 24. Type copy is at page 22. Lordship, I am very fair. Because Lordship is correct to that in second paragraph. The newly appointed, page 22, my lord, of the writ petition, Annexure 2. The newly appointed commission basis sub-registrar will be remunerated in accordance with the provision contained in para 50 of the chapter as per instruction and others contained in the registration manual, Assam. Necessary office accommodation to be arranged by him at his own cost. Books, forms, etc. will be supplied to
This
him.
is what is the bone of contention.
Yes, Lordship.
This is
if
for
necessary-
his, but whether this is for the government.
If necessary.
Where is your regularization order?
Regularization order is at page page 39, Annexure 6, my lord. Two orders are there. One cabinet decision, that is Annexure 5, page 38. Let us go it first. Page 38, Lordship, of the my writ petition. Lordship got it? Page 38. And regularization order is page 39. Because Lordship knows there was no rule. Service rule was made in 2010 September only. Prior to that, there was no service rule in Revenue Registration Department.
I got your point.
Pension. He will be getting pension, albeit my lord, whether under the 1969 rules.
But
or-
have you been deducting NPS from him?
Yes. Yes.
Hussain Ali, my lord,
So the principles
Hussain
of
Ali-
waiver, estoppel and acquiescence will also come into play.
after the first round of judgment of
Order to
of my lord Justice Ujjwal Puya, we filed.
This was taken up on appeal also.
Yes, appeal is dismissed.
Hussein Ali was taken up on appeal.
Appeal also,
Yes,
appeal is
appeal.
dismissed.
What happened in the appeal?
Appeal, my lord,
Dismissed.
Hussain Ali, my lord, appeal was dismissed.
Any observation therein?
No, nothing. We only, my lord, harped on the materials on record, whatever the stand was taken by the finance department as well as by the, my lord, revenue department therein. And more particularly, my lord, with regard to the note at rule 44 of the pension rules, which excludes, my lord, that if the
Right, the commission.
commission. So if there is any commission or fees, there is an exclusion clause. But the honorable
But
division.
here,
Those things that is finance.
just a moment. Here, the Siddiq Ali commission was being received by Hussein Ali.
Commission was received by Hussain Ali.
Hussain Ali, his,
Coming to you, I'm trying to only understand, not taking a call. Now, how was the remuneration of Siddiq Ali being paid?
It was paid by Hussain Ali because that.
From the commission received by him?
Absolutely, that is
Absolutely.
explicit.
Hmm?
That is.
Correct.
That is explicit from.
Then-
also commission.
Then how can that decision be applied in your case,
Yes.
Mr. Constable?
I.
Commission, you are the employee of an agent. The agent is paid a commission. Out of that commission, for his own convenience, he has engaged somebody. He parts a part of it to that. The person who is there for his convenience. How can the government, you are not getting paid from the government for that period? There was a post created in 2008. From that day onwards, you were adjusted, rightly, wrongly. You were adjusted. From that day, you are getting your salaries. Prior to that, the commission, which is a legal thing, you are not drawing a commission. Commission is drawn by Hussain Ali. Siddiq Ali is paid out of that commission only.
Hmm.
And there is no approval of the government for your engagement because that engagement is for the works required to be done for the government by Hussain Ali. What do you say on this proposition? That's the answer. Clear that part. You get your money. Otherwise, we'll have to hold that judgment will not cover you. You come to the judgment of,
Division bench,
no, single bench.
single bench, that 2014 judgment. Lordship, in additional affidavit, I have annexed every judgment. That page 109, annex 12, my additional affidavit. Yes. From my Lord Justice Jugesh Sharma judgment, every judgment I have annexed. That apart, we have some additional pleading.
This case, I appeared for there is no issue. I appeared in Hussain Ali in the, my role was,
this something like lordship has appeared for the tenant, now the under tenant is before my lord. So there is
For pension and public
Expressly-
relations department.
Especially there is no class, my lord. Especially there is no class. Now the honorable single bench.
Come to page, for para 24 of that judgment.
Para
Para 24.
Hmm.
The Registration Act
Hmm.
is an act to consolidate the enactments. Should I read, my lord?
You read 26.
26. From a careful analysis of the above, it is evident that sub-registers appointed on commission basis discharge their functions in the service of the state government. But instead of salary, they are paid commission. Two ways, either salary or commission. Their appointment, dismissal and suspension are in the hands of the state government. Their continuance in service beyond 55 years depends on the Inspector General of Registration and the state government. Matters relating to their leave are regulated by the Inspector General of Registration. Reductions are made on account of income tax and other use from their commission. But still, my lord, one thing remains.
Yes,
It may be very temporary. I was in service. If I was not in service, how my
no, you are in service.
how my service could be regularized?
That is a different thing altogether. That is the benevolence shown to you. Now, whether that benevolence will also give you the service benefits from the date you were engaged, because you were not engaged as a commission vendor or a commission, whatever, sub-register, whatever it is. You were engaged by the sub-registrar for convenience of his work. You are not paid a commission. You are paid a salary.
Not salary. I was paid a part of commission
Whatever it
for
is,
running the office.
whatever it is, something. But that is not a commission given to you by the government. It's a commission generally given, drawn by the sub-register for himself. He could have done that work. But he wanted somebody to assist him, so he got you. Now, how will that bring you at the same level with him?
That's a thin, very thin, but
Then we'll have to consider,
it will have a bearing.
because what we say would be the law, subject to appeal.
Huh.
So we'll have to be very careful, because if we also bring them into the same level
Hmm.
of a sub-registrar,
Hmm.
this judgment may have an application in some other fields of similar nature. Although we may not even think of.
Critically, I will have to study. And I will have to reply also the affidavit filed by IGR. In the meantime,
So I don't think so you require an affidavit here.
Affidavit, more particularly, I want to bring on record, my lord, the amendment made to the pension rules, because rule 2A has now come in.
That is a question of law.
Law.
A fact,
I will.
study, you can just place it. So you get over this.
huh, huh. Lordship, in the meantime, I will also file a reply of the affidavit.
I don't,
composition.
replies are not required. It's we are in the
Pure
main
question. Oh,
law only.
pure issue.
So get that thing cleared up.
And perhaps, my lord, because my submission will be, my lord, because rule 31 is also not affected.
231 will not come in this case.
Rule 31 is the basic, my lord, provision of the 1969 rule. That is the foundation for qualifying service. The rule 31, my lord, for a moment, say.
No, no, no.
Yes. I will not open the cards today.
Mr. Islam has got it.
Very excited, my lord. He's being armed with.
No,
that
no, we want
message.
him to work on that.
Yes.
Lord. After vacation then.
Now, another, just to test what I was telling you. Hussain Ali engaged you. But say you are working for a considerable period of time till 2008,
24 years.
22 years. Now, one fine morning before that was converted to a regular sub-registry, he does not want your services, he asks you to go. What would be the effect? Would a writ petition would have been maintainable at that point of time?
That Lordship is raising the question whether I am a public servant or not.
Because that is the issue raised in the case of, what do you call that, Hussain Ali, and the
Connection
finding
to
of the
the-
learned single judge
Connection.
was that he is doing the same nature, holding the same status and powers as that of a regular sub-registrar.
Hmm.
Whether that can be applied in your case also.
Yes, yes. Lordship, I have understood. Whether Article 14 and
14 is too big a concept. We need not go to that extent.
But otherwise, Supreme Court says that is well settled 2006.
Supreme
At
Court,
least
any judgment,
similarly situated. Supreme Court
but you are
says-
not similarly situated. He is an appointee of the government and you are an appointee of him without there being a delegation of power to him by the government that you set up office. That setting up is for his convenience only.
Hmm.
Or you show me that the setting up of an office of a sub-registry, engagement of employees therein, had also the approval of the government.
Oh.
Develop your argument on that lines.
Hmm.
That it's not the sub-registrar only who is to be appointed,
Hmm, hmm,
but it also required
hmm,
persons below him.
hmm, hmm.
Government did not appoint. It was appointed by the sub-registrar,
Yeah.
but we are also accordingly deemed to be appointees of the
Huh.
government because without any further change,
Hmm.
our services were regularized.
Very good.
Try that. Then let's see what Mr. Borpujari replies.
Yes, sir.
We'll have it on
Tuesday.
Thursday
Okay.
next.
Huh?
Thursday next.
You know,
Otherwise, I'll forget.
Lordship, otherwise,
Tuesday even my.
I am busy. After vacation,
No, no.
it may take time. It may take.
No, time is enough with me. Thursday, others I'll forget. I want to hear now. I'm very eager to hear your arguments on that
Lordship.
point. Thursday,
Yes, Naman.
as agreed to by the Learned Council for the parties, registry to list this matter
Thursday?
again on Kimanobu,
Huh?
19/6/2025 for further hearing, 19/6. If you can't come back at 2 and argue, I'm here. You,
Today, no,
we have delineated the areas,
no, today it is not.
not possible. Then, if you want, I have a Lok Adalat on Saturday. After that, I can hear you. No problem. Very interesting. I want to hear you.
I must study the
You study.
initial point.
You study, come back on Thursday. No adjournment,
Thursday 19.
19.
Yes.
And Mr. Borpujari, what he argues, he argues. Now, for you to argue, would a sub-registry be limited to the sub-register only? Or would it
Sub-registrar
be
alone.
a setup? Because without any further thing, or any further development taking place, you have regularized his services. Why?
And that is true. Now, whether prior to pre-regularization, whether there was any ratification from the government.
Because why I say so, while you regularized it not as Hussain Ali, but sub-registry so-and-so.
As a establishment.
Mr. Islam, sub-registry so and so. So you took up the whole sub-registry. That means what? You are giving at least an ex post facto approval to the activities going on there.
Now, that will attain the, after regularization.
Why did you regularize him then?
No, regular, because there are two orders. First, the sub-registry was, my lord,
Created.
Yes, sub-registry was converted to a full-fledged sub-registry. So it becomes, it attains the character of a pensionable establishment. Now, after it attains the character of a pensionable establishment, definitely then the issue will arise, my lord, whether his past services can be. Because prior to that, ad hoc.
Thank you. You gave me the click now. That's the point.
That's
Mr. Borpujari, that is the end of the story. So, you considered the thing as an establishment. He came in as an establishment. So, once he is there, whatever happens to Hussain Ali will happen to him also.
because the sources will have to be examined, my lord. Source of appointment.
Forget it. Forget it.
We'll distinguish.
We'll have it on Tuesday.
Not Tuesday, my lord.
Tuesday.
Tuesday, I am in.
For you, it's better Tuesday.
Thursday, my lord.
Thursday, okay.
Only. Then at least I will get enough time to study it. কত হবো? আছে কত? 18
You try to counter this again.
These are the judgment I am relying.
Interesting.
Because
Very
that-
interesting.
That terminology pension.
Ah, you are not. You are not coming with the correct answer. Work. And don't get me big concepts.
Lordship.
The concepts which are fitting into the thing, which will take you to the level of Hussain Ali, just remain there. Mr. Borpujari, thank you, but try to counter that also, what you have.
Definitely.
Because when you have said establishment, he comes in.
Pensionable establishment.
That is a different thing.
Make an attempt.
Then the principle that is applied to Hussain Ali automatically will apply to him also.
I will make a sincere attempt to persuade my lord that.
I'm open. I'm
Yes, yes,
just thankful that something clicked.
We are always obliged.
Give you.
Hello. Yes, Sharma.
Yes, Mr. And it's okay.
He's going in court number, Mr. Honorable.
Still going on.
He's dictating the judgment.
But you were supposed not to be here. The mention was made personal inconvenience.
No, if it is not.
It was the inconvenience.
Today we will complete it and we'll deliver that order on that. I've started off. Wednesday we'll finish it up. Also, the matter order could not be completed. The delivery of the order could not be completed today. Accordingly, registry is directed to list this matter again on Thursday. Thursday. On Thursday for delivery of orders. Yes.
Lordship, I have made a telephone call, but I could not get a response.
You need not. You
Lordship,
tell me how this repetition is now maintained.
only thing is that regarding the appointment, Lordship, they were appointed against sanction vacant.
Madam, that is something you will have to take up before the division bench. You have taken up. That is the end of the matter.
Otherwise, Lordship,
And you are the same person.
Lordship, we are the
Then-
same.
So in that view of the matter, nothing survives.
Only that, another thing, Lordship, I will just point out, Lordship, to pass out. Lordship may come to page 47
Hmm.
of the petition, Lordship. There is an affidavit.
You had filed a review petition.
Review, I'm not aware, Lordship. Page 47 of this writ petition. This is an affidavit in opposition filed by the Joint Secretary, Government of Assam.
Hmm.
They are the same petitioners, Lordship, their
Hmm.
earlier writ petition.
Hmm.
Their Lordship may come to paragraph 5, page 48. May I read, Lordship?
But this is not you. You say 20 persons are required, muster roll remain to be appointed on. Are you within the 17 persons appointed on regular basis? You are not. Currently, 20 muster roll workers remain to be appointed on regular basis in the tract. You are within that only.
Lordship. Lordship, they were appointed against vacant, sanctioned vacant post, Lordship, and they have stated that vacant post been available in that department. There is no necessary of creation of post of master workers, page 49.
Do you have that decision?
Lordship, the Upendas I have, Lordship. The writ appeal. Just reported 2025 jail, if I have a copy.
Anything more, madam?
May I read, Lordship? Paragraph 22, it is however heartening to learn that the state government has agreed not to terminate the master roll work charge and similarly placed employees working since last more than 10 years, not in sanctioned post, till their normal retirement except on disciplinary ground or on ground of criminal offences. The state government.
Show me how you are in the, which is the order or where is the material to show that you are holding sanction post?
If,
Only that paragraph in the affidavit.
My lord, then that will go to contrary to the prayer. If.
Lordship, page 26 is the detailed particulars of the petitioner's lordship.
Now show me that you are holding a regular sanction post.
Dear Lordship, another is at page 29. This is the list of the master workers engaged prior to 1/4/1990.
That is different.
Lordship.
Show me where is that material that you are saying that you all are holding sanction post. Or where is that material in the writ petition? Contentious. If writ petition is to the action of the director prior to his retirement to advertise. So where is that question? You are not holding that post. Those are vacant posts, regular vacant posts, but you are not appointed against that.
Otherwise, Lordship, the affidavit, it goes on to say that.
Let us see the affidavit.
Lordship, that Lordship will find at page 47, it starts
Hmm.
at page 47. The
Read
relevant
that.
page 48, then
Read
with
that.
regard to the statement made in paragraph 5 of the petition, I say that there were total of 38 persons engaged on master roll basis in the
Hmm.
Directorate of Geology and Mining, Government of Assam, whose services were utilized as and when required for conducting geological field investigation works. Out of the efforts.
So
of
till
38
here, you are not in regular vacant posts. Now read further.
Out of the aforesaid 38 persons, one person, Ratul Sharma, passed away quite some time ago.
Hmm.
17 persons were appointed on regular basis against sanctioned vacant posts in the year 2005.
Hmm.
Currently, 20 master workings remain to be appointed.
So where is the statement here that you are working against sanction post?
Actually, this affidavit was filed by one of the petitions, Lordship, filed by the present petitioners.
Fine, I accept that. I accept here, but where is that material?
Has been stated.
Then
And Lordship, another affidavit was filed by the Finance Department in the same matter. Lordship will find it page 50, Lordship.
50.
Lordship. And the relevant portion 51, paragraph 5, Lordship.
You come to page 49. Says that sanction vacant posts being available in the department, there is no necessity for creation of posts for master roll workers. That is what they said. But you were not regularized, unfortunately.
That was
But then
others
that
who-
is superseded by the division bench. It is not a case that you are working against sanction post. Then what does the,
The paragraph 5, page 51, Finance Department affidavit.
Hmm.
That as regards to the statement made in paragraph 5 of the writ petition, the deponent begs to state that the finance department has not approved the regularization of services of any muster roll worker under the Directorate of Geology and Mining. However, the finance department agreed to the proposal of the Power, Mines and Minerals Department for filling up of 17 sanctioned vacant posts in the Directorate of Geology and Mining with the muster roll workers in the department during.
this again, you are not holding. There were vacancies, they said, okay, fill it up. That did not come, that will be now Upenda's division bench.
22 and 23.
Hmm?
Para 22 and 23 will override everything, madam. Oh, Pendas.
Anything more, madam? Heard Ms. A. Talukdar, learned counsel for the petitioner. Also heard Mr. R. Dar, learned additional senior government advocate appearing for all the respondents?
Madam, finance, my friend, R. Pujari.
For the respondents number 1 and 2. And Mr. B. A. Solia is here. Who should I put? B. Gugui.
Pujari was here.
Mr. R. Borpujari,
He
learned
appeared.
standing counsel, finance department appears for the respondent number 3. The petitioner, by way of instituting the present proceeding, has prayed for the following relief. Page 23A to A. Also, the petitioner's hearing had raising a similar grievance earlier approached this court by way of instituting a writ petition being writ petition number What was your writ petition number?
Lordship, the earlier one,
Hmm.
3810. 3086 oblique 2010,
Where do I get it?
page 47, Lordship.
Had earlier approached this court by way of instituting a writ petition being WPC number 3086 oblique 2010. So they said writ petition was along with other analogous matters considered and disposed of by a coordinate bench of this court wide an order dated 2012-2023 directing the state respondents to steps for regularization of the services of the petitioners involved in the said proceedings. And for the said purpose, the directions were set out in paragraph 66 of the said order. Also, the state, being aggrieved, had assailed the said judge order dated so and so by way of instituting an intra-court appeal, by way of instituting a writ appeal being writ appeal number. Where is that? Writ appeal number 645 of 2014. Also, State of Assam versus Upendas and others. The writ appellate court, the division bench of this court, wide, judgment and order dated 8/6/2017 was pleased to dispose of the said appeal by accepting the undertaking, the undertaking given by the state respondents not to terminate the muster roll, work charge, and similarly placed employees working since last more than 10 years, bracketed not in a sanctioned post till their normal retirement, except on disciplinary grounds or on grounds of criminal offences. Also, the division bench further noticed the decision of the state government to enlist such employees in health and Accidental and Death Insurance Scheme. First, having noticed the said decision of the state, comma, the division bench proceeded to pass the following directions. Para 22 and para 23. First, during the pendency of the said writ appeal, being writ appeal number 45/2014, the present writ petitions were instituted by the petitioners, praying for regularization of their services. However, the prayer as noticed here, as extracted herein above, made in the writ petition would go to reveal that such prayer for regularization was so made subject to the result of the proceedings in WA number 45/2014. So, Ms. A. Talukdar, Learned Counsel for the petitioner, has, by referring to the directions passed by this court, referring to the observations made by this court, by the division bench in the case of Upendas bracketed Supra in para 22, that the said directions were so limited to persons not working in sanctioned post, has contended that the petitioners herein were working in sanctioned posts in the Directorate of Geology and Mining, and accordingly, the said directions the directions laid down by the division bench in the case of Upendas bracketed Supra would not be applicable to them. Full stop. She further submits that in view of the fact that the petitioners herein were engaged against sanctioned post, comma, they would be entitled to have their services regularized in terms of the policy decision adopted in this connection by the state respondents. Full stop.
Lordship, here, page 36, there is a proposal, Lordship, sent by the director to the joint secretary. This regarding filling up of sanctioned vacant posts. The petitioners names are there.
Okay, fine. Full stop. On a query made by this court to the Learned Counsel for the petitioner to demonstrate as to how the contention that the petitioners were working against sanctioned posts have been so made, comma, the Learned Counsel for the petitioner has failed to demonstrate any basis for such contention raised in the matter. Also, be that as it may, the same very petitioners being also involved in the proceedings before the division bench in writ appeal number 45/2014, comma, and the same having master rule observed and casual organization of their services with consequential benefits such as pension, comma, they said direction passed by the division bench still holding the field, comma, it is not open to this court to take a different view in the matter. Also, further, as noticed herein above, the petitioners have also failed to demonstrate as to how the decision rendered by the division bench in the case of Upendas bracketed Supra would not be attracted to them, and they would have and they would be entitled to have their cases considered for regularization. First up, in view of the above discussion, this court is of the considered view that the decision rendered by the division bench of this court in the case of Upendas would stand squarely applied, squarely attracted to the case of the present petitioners, and they would not be entitled to any other benefit other than that extended widely by the division bench in its decision in the case of Upendas Supra. Accordingly, the present writ petition is held to be devoid of any merit, and the same stands dismissed. However, there would be no order as to cause. Anything more? Sorry,
They're getting the minimum pay scale under the. that
they are getting,
judgment.
oh, itu upward likhi dia sun. Apa upward likhi diba? Ami discussion. At this stage, it is to be noted that the benefits extended by the division bench wide its decision in the case of Upenda Supra is being received by the petitioners. Full stop.
Only
Anything
the
more?
regularization.
That cannot be. Itu kabat zakat of kumari.
Much obliged, much.
Item 1, 8, 9, 10, 11, 12. We'll be passing the orders. Item number 2 to 7, today will not be possible. We'll fix it and we'll pass the orders. 1, dispose koidia. 8, dispose. 9, dispose. 10, 11, 12. Huh? Full? 26 to kuning moi.
7, my lord, we did date, my lord.
2 to 7 will take some time. We'll pass the orders. Others we are disposing it of today. But you will get the orders by Monday or Tuesday only. 8, 9 gone. Done. 8, 9, 10 done. Disposed. 11, 12 disposed of. No, it need not be. I'll pass the orders. But you will get the orders only by Tuesday or Wednesday.
Only I have mentioned only resolution number 5720. That part which you mentioned.
5720 Lumding.
Yes, Lumding. This is issue is the separate.
Oh, we'll pass. We'll take it.
Resolution is there.
Oh, we'll take care of that. No.
Regarding that specific, my lord, one order is of the commandant is there on 3rd of August 26. There is only specific, my lord, where before charge sheet was given on the same day, 3/8/2016, and the order also of 3/8/2016, whereas so and so Constable Suman Sinha company will be tried under the SSFC by the so and so and 17 BSF on 16 August 16 at 11 hours for committing the offence.
No, I'm not on that. Where is 1742? 74.
70. That is not there. And only one thing I would like to point out that in the charge sheet there is a approval by the DIG.
That approval is not.
Yes. But regarding that, my lord, that any other specific that it has to be under the rule section 74 specific order. I have not.
So without that, how can you invoke that provision?
That is the difficulty.
Very, very categorical. And rule 46, I'm not going only. 47.
46.
46, I'm not going. Act itself, bars.
It's, if I'm reading again,
47, madam.
47, huh?
74 to maybe before that, my lord, a PT security force trial maybe after that only, my lord. When there is no reasons for immediate action and reference can without determine the discipline be made, the officer empowered to conduct.
So you must say that this will disturb the route, this one. So we are proceeding with a summary postcode trial. Otherwise, offense under 46, you will go for petty or general.
But I am finding any such may come these 2 days. Nothing has come out, but how much fatal? But is code section is specific. That is
Specific. Because you will have to give him a opportunity
yes.
to defend. And if that be so, the guilt plea pleaded by him is in a proceeding which is otherwise not maintainable. So that guilty pleading will not have any effect.
I have to go by the record, otherwise, my lord.
Give me the records.
Yes, yes.
Mr. K. Parasa, Learned Counsel for the respondents in terms of the query made by this court on 10/6/2025 has on instructions submitted that there was no decision arrived at in the matter by the competent authority in terms of the provisions of subsection 2 of section 74 of the BSF Act. BSF Act. It will open.
ওলোৱা আছিল।
And there was great reason for immediate action and a reference which would otherwise affect the which would be otherwise be detrimental to the discipline of the before deciding proceed against the petition. But before proceeding, some other segment was put against the petitioner herein for the offence alleged against him under section 46 of the BSF Act. Said assumption and now consider and quite possible find what is and according raised in Wednesday. Really close. Recording, record is. But even if subject to correction, if we require just one of these, even if we hold that you are entitled to comply, but we will not provide for any salary from the date you were said you were not there till your date of reinstatement. Will not provide. Notional fixation will be given. Seniority, other continuity, everything will be maintained, but no salary. And we will, we'll also provide a liberty to them that these allegations, if they wish to proceed against you in terms of law, accordance with law, they are at liberty to do that.
And one,
Because we will be interfering on a ground of technicality. But Mr. Chakravarti, no salaries.
one thing only, my lord,
4%. my lord.
That's why we are giving him back the work. Ask him not to make money like this.
being the force, my lord.
Not to retain money like this, sorry, not to retain money like this without explanation. I was against you when I examined 74-2 only otherwise the facts don't mandate a consideration, but it's a technical thing, can't help it.
But regarding being a force, my lord, BSF, my lord, at present, his medical status may be also.
That you do whatever you want to do.
That has to be examined, my lord.
And then otherwise, I'll put him back in service. So till that day, he'll be a regular employee. Thereafter, his further continuance.
Yes, yes.
You do as per your law, but if it is there, you will have to pay him the full. When now, how many years would be? More than 10?
No, my lord. Just I am saying because he is outside.
He is doing exercise and all, running around. Or he is with you in the chamber.
He is outside more around 9 years.
My doing some private.
How much, what is the tenure?
That information.
No, it's
dismissed in 2016, my lord. So
16.
16, about 9 years,
9 years, sir.
30 years at the time of filing. Now 39 years must be. Time is there, 39.
2007. So another 16 would be 11 years. So another 9 years. So around 20 years plus he will be having service. So once he comes in, send him on compulsory retirement or medical, whatever it is, he'll get some benefit. Okay? But no salary. That period I'll direct for regularization, notionally, continuity in service, seniority. But final view on Wednesday. God knows where I'll
My lord,
reach.
things may always change, my lord.
No, but this was I was totally against you.
My lord.
He knows. But when I read 74-2, I could not proceed
It
further.
matters, submission is very difficult unless we catch this way, that way. Otherwise, on merit, my lord,
Otherwise, this was a case for immediate disposal, dismissal. I mean, the writ petition was to be dismissed at the threshold. But given the technical plea you have taken,
yeah.
I was stuck there. Okay, fine, we'll see. Raghu?
My lord, I am sorry, my lord. One request can I make? My lord?
Yes, yes.
My lord, item 24. My lord, may I pray, my lord, can it be kept as part heard, my lord?
No.
Because, my lord, at the hearing stage, my lord has allowed them to file affidavit.
No problem.
Next date also, my lord, if they delay,
Oh, come back to me if I'm here.
my lord, in
Doesn't, because it's too long away.
the holidays will be
That
not be
should not, it
complete,
doesn't look proper.
my lord.
That's what. Anyway, that matter is here. I'm only on that small point. Mr. Dhar will clear that, then we'll proceed. And Mr. Dhar has serious objections to your prayer made by you. He's standing there back. He has serious objection. Yes, Mr. Dhar, you have serious objections. So I'm not entertaining them.
My lord, in item 11, 12, my lord has fixed it for final orders, my lord.
Huh.
Lord, my submission is maybe just, my lord, I have just one instruction which I have received today.
Have you given a copy to the learned counsel for the petitioner?
Only in
It's
the,
part of my affidavit. In the first case, the same thing is there, Lord.
just a brief summary of the entire.
Those are part of my affidavit. That our difficulty, what is the reason for extending the contract? And in this regard, Lordship make a kind.
No, I hear you, without hearing them, it's not proper. Can you get Miss M. Sharma?
They are the I left.
No, my lord, here only submission is regarding that, my lord, determinable contracts under specific relief act, my lord.
No, I'm sorry.
Those-
That we have already rejected.
Not one judgment, if my lord, I am relying, I have given paragraph.
My lord
10,
Justice
Paragraph 10, my lord.
Allahabad.
Yes, division bench. It relied on a judgment of the Supreme Court, my lord, Kerala State Electricity Board versus,
Mr. Gupta,
that is,
I accept, I understand. It's a determinable contract. Now, your policy itself says that for the extended portion, if he does not accept, you will have to go for a fresh tender for that portion. Now, in that circumstances, how can you cancel the thing? Because he is not at fault. So, you're the determinable contract, that termination of the contract on that count is bad.
yes.
If it was a stipulation that he'll be given, if he does not accept, it will amount to total contract being gone, then that would have been the place where you will cut it. But here, you yourself said that point A to B is the
Yes.
original, but now we have extended it to B1. So B to B1, you will have to take. If you don't take, okay, we will go for a fresh tender. You don't say that if you don't take, we are liable that the entire contract will be cancelled.
Yes, but it is connected, Mal, the train is connected and.
Your provisions are also connected. A man comes to you with the provisions only. How can you resile from that? You cannot. We are not permitting you.
Passengers inconvenience is also there.
You should have, you know the better.
Five
You are the
minutes.
railways.
Now the trains.
Mr.
halted.
Gupta, you are the railways. You know every in and out of your operations. Why did you put that condition there? You should not put that condition, right? So let us give it a quietus.
There are two clauses in the contract, Lordship, 8.22 and 8.24, and also 10.5, Lordship.
8 point?
8.22, 8.24, and 10.5. So it gives some right.
10.5.
5.
What does it say? 8.22?
8.22. Leaseholder shall complete loading, unloading operation from lease parcel within the scheduled stoppage time of the train in intermediate station.
That is of no application here. 8.2.4.
Any detention cost to the train on account of loading, unloading of parcel
That is also of no use here.
on the part of will
That is
render-
also not the issue involved here. Then 10.5.
10.5 partial awaiting loading at originating station.
Sorry, these three are for the loading. See, a VPU loader, if he delays loading,
Lordship.
the consequential would be the train is delayed. Here it is not that. He says, my station is Guwahati to Jaipur. I'll not go, whatever it is, Guwahati to Jaipur. I'll not go to Dibrugarh. I'm not loading from. Why that is his discretion, because your contract says if you don't do it, if you don't also load from Dibrugarh to Guwahati, because the train now originates in Dibrugarh, then we will advertise the part from Guwahati to Dibrugarh as a fresh advertisement for that portion. So that clearly states that he is not required.
But what is the reason of doing?
That is
doing
because
this?
you take action against the person who formulated that conditions. He should not have incorporated that condition. From which division it was issued?
London.
Lam-
For the extra period which they are halting, now they are being penalized also for it.
That is different thing
Penalty
altogether.
is also imposed.
That is different thing altogether. We'll pass orders. We'll consider your this thing. We'll pass orders. Anything more? No. बोला युद्ध करना